Good evening, everybody, and welcome to the next instalment in our SEN legal webinar series, which is taking place throughout November. My name is Nicole Lee, and I'm a senior solicitor with SEN Legal, and I'm going to be delivering a presentation to you tonight all about child to adult transition with a special focus on social care. Before we launch into that, I just wanted to tell you a little bit about the webinar series for those of you who may be new to us. We are running a series throughout the month of November, and we're hosting a webinar every Tuesday and every Thursday throughout the month. Every Tuesday, there will be a legal presentation delivered by one of the solicitors from SEN Legal. There was a presentation by Hayley Mason last Tuesday, which is now available to watch through YouTube, through our website, and through our various social media channels for those of you who may have missed it. There will be references to Hayley's presentation throughout mine, so it might be a good idea if this is an area of interest to you to actually go back and watch hers if you haven't seen it already. And every Thursday, there will be a presentation delivered by an expert or somebody with specialist knowledge who will come along and tell you a little bit about their field of excellence and hopefully provide you with some tips to take away with you. This week, we are being joined by Juanita Hurley, who is a highly specialist speech and language therapist, and she is going to be speaking all about the differences between ASD and developmental language disorder and how you may differentiate between the two if there is a question mark over that diagnosis. Last week, we were joined by Melinda, and she delivered a presentation all about sensory processing disorder. It's a bit of a mammoth. It's really quite long, but it's full of really, really good information, really good strategies for parents. So if you do have a child who has sensory processing difficulties, or if you know somebody who does, I would really, really recommend that you send them along to have a watch of that. And next week, so next Tuesday between 7 and 8, we have a webinar from our principal and director, Melinda Nettleton, and she is talking about off-rolling, admissions, exclusions, and essentially getting the school you want and staying in the school that you want. But enough about that. Hopefully you're all here to hear me talk about social care. If you're not, now may be the time to dip out. I won't be offended, it's not for everybody, but hopefully there will be something here that is of use to you. So I'm just about to share my screen with everything crossed that it will work out as it should. So fingers crossed, yeah, participants can now see your application, perfect. So as I said, I'm talking about child to adult transition today with a very special and heavy focus on social care. I'm not necessarily going to launch straight into the transition procedure under the Care Act of 2014 because I tend to find that the transition takes parents a little bit by surprise and young people for that matter. Often it's not very well prepared for, and that's not how the legislation and guidance intended it to be. So I am actually going to talk a bit about what should happen in the lead up to the transition and what you can actually expect from year 9 as well. I'm hoping that'll be helpful to some of you. Bit of boilerplate. The material here, I assure you, is all completely accurate. It's up to date, and it should give you a broad overview of the transition procedure. What this presentation can't do for constraints of time and confidentiality is it can't focus too deeply on individual circumstances. Just a reminder to everybody attending that we will be taking questions and answers at the end. Hayley Mason will be joining me to give those questions to me to answer. Everybody can see the questions, so everybody that's in attendance can see the question and answer tab. So I would urge you to just have a little think about the information you're putting in there. Social care can be a very, very emotive subject, obviously, and it often requires quite a lot of personal information to be able to advise fully. We're not going to be able to do that. That's beyond the parameters of tonight's presentation. So I would advise maybe steer clear of putting too much personal information out there about yourself. But in terms of generic advice and an overview, this presentation should cover everything that you need to know, fingers crossed. So topics for discussion, as I said, I'm going to talk about preparing for adulthood a little bit first, focusing on the annual review procedure for those with EHC plans and what can be expected for those who don't have EHC plans. And then I'm going to talk a bit about the code of practice as well, because that really covers what should be happening before 18 and actually what should be building up to that transition from child to adult social care. Moving on from that, I'm going to discuss the child to adult social care transition process as well, what can be expected, what obligations are on the local authority, and the criteria, the correct criteria that are to be applied by local authorities. Because those of you who aren't new to our webinars, it will be no secret that quite often local authority policy seems to trump those correct legal procedures. So I'm going to highlight the correct test for you. And then I'm going to talk very, very briefly at the end about the potential routes of redress if you're having problems with the transition procedure. I'm not going to go into it in a huge amount of detail because there will be significant overlap with a presentation that's been delivered by my colleague Richard Nettleton later on in November. He will be talking about non-tribunal routes of redress, so judicial review complaints procedures, which will very heavily tie into the topic that I'm discussing tonight. I will talk about its relevance to social care, but I'm not going to go into chapter and verse on the procedure because that is what Richard will be covering later in the month. So, preparing for adulthood. The premise of the new legislation and the new regime, there was a heavy focus on the fact that planning for adulthood should begin long before a child reaches adulthood, which actually is quite common sense. If you're not preparing for adulthood in a timely fashion, it's going to come upon you all too quickly, and there won't have been time for proper assessment, for proper transition, and for proper consideration actually of what a child, soon to be an adult's needs would be and what provision they may require. So if we look at the SEN regulations and the code of practice, what is required actually for children with EHC plans, and in fact without, is that preparing for adulthood should begin to come into focus in year 9. So for children with EHC plans, it's the year 9 annual review. For children with disabilities that don't have EHC plans, chapter 8 of the code of practice, which deals with transition, actually applies equally to those children, unless it specifically states that it applies only to those with EHC plans. So what is preparing for adulthood? So we have a really nifty little definition set out in Regulation 2.2 of the SEN Regulations 2014, which basically defines preparing for adulthood as including preparation relating to finding employment, obtaining accommodation, and participation in society. So those are really nice broad headings, and I think that's intentional. It's not supposed to be an exhaustive bullet point list. They are nice broad headings, and there are very few things that you could come up with when you're thinking about transition to adulthood that wouldn't fit into one or more of those subcategories. So what you're really thinking about when you're dealing with preparing for adulthood is finding employment, obtaining accommodation, participation in society. And it can help if you structure your conversations with those broad headings in mind. If we're looking at when preparing for adulthood can start for children with and without EHC plans, I just wanted to run through this because people can be quite unsure when EHC plans are late in the game, if you like, and maybe not in place by year 9, or in place when year 9 has already begun. So if you have made a request for an EHC needs assessment and you're going through the EHC plan process in or beyond year 9, it's an extra requirement on the local authority to actually obtain advice and specific information about preparing for adulthood as part of the initial assessment. And you can find that in Regulation 6.1G of the SEN Regulations of 2014. And the premise of that is so that children who are obtaining an EHC plan relatively late in the day aren't disadvantaged by that fact when it comes to preparing for adulthood. So ultimately, if you are going through the EHC plan procedure at that point, when you get your final plan in your hand, you want there to be consideration of preparing for adulthood already in the document as a baseline for you to build on as part of the subsequent reviews. For children who already have EHC plans in place before year 9, and it may have been for many, many years, it may be quite fresh, it becomes a legal requirement that the review itself must include, that the EHC plan, must include education, health and social care provision specified with regards to preparing for adulthood and independent living. and that's Regulation 12.3. And that's a good piece of regulation to be highlighting to schools, colleges and local authorities in reviews if they're starting to say, well, we think it's too early, actually we're not going to start specifying provision now for adulthood, they're only 14, it's all a bit soon. It is actually a legal requirement for children with EHC plans that this all kicks off in year 9 and when they are 14 years of old, so don't be afraid to assert that. Following on from that, it is a requirement for all annual reviews beyond year 9 to consider what provision is required to prepare the child for adulthood. And if there are attempts at the school, you can find that provision in Regulation 26. And if they're not at a school, so if, for example, they're receiving an EOTAS package, then it would be Regulation 21.6. That again is a good one to point at, because the requirement is very much on schools and colleges to be focusing on the adult transition, to be focusing on preparing for adulthood. And in my experience, I'm sure none of my colleagues would disagree, that so very rarely happens. You tend to find that there is no recognition that the year 9 review is any different, and it will follow the same old pro forma, focusing heavily on outcomes, in fact, with very little consideration of any specific provision with regards to moving towards adulthood and independent living. So in the run up to your year 9 review and in subsequent reviews, you really want to be reminding the SENCO or whoever it is that's chairing the review that actually this review must have that focus on preparing the child for adulthood and really concentrate the mind on that fact. Ultimately, preparing for adulthood should be a key focus, particularly for children with EHC plans from the age of 14 onwards. But as I said, Chapter 8 of the Code of Practice, which deals with preparing for adulthood, applies just as much to children without EHC plans as it does to children who have them. So whizzing through the SEN Code of Practice, it's Chapter 8, it's really quite lengthy. I just don't have the time to run through it all in any level of detail with you tonight, unfortunately. If you do have a child that is in year 9 onwards or facing adult transition, it's well worth the read. You can easily find it online by Googling or searching for SEN Code of Practice 2014 and going and flicking directly to Chapter 8. That will hopefully give you some guidance and move you in the right direction. But ultimately, as I've said, it's in the introduction, it's not a numbered paragraph, so I can't give you a paragraph to go and search. But the introduction to paragraph 8 makes it clear that the principles and the guidelines contained in the code and contained in Chapter 8 actually do equally apply to children who don't have EHC plans, who have special educational needs, unless it's otherwise stated. So there are a few chapters which do relate specifically to EHC plans, annual reviews of EHC plans, but some of those principles actually, when you read through them, I would still be quite comfortable as a solicitor arguing that those principles should apply equally, whether there's an EHC plan in force or not. There's a very, very big focus on aspirations, desires, views, wishes and feelings of a child. It's throughout the code, it's throughout the guidance relating to the Care Act, which I'm going to come on later. And there is in fact case law relating to SEND tribunal proceedings, which really stresses the importance of the views, wishes and feelings of the child or young person, and the fact that when the local authority is making decisions relating to that child or young person, that those views, wishes and feels should really be central to the decision-making process. So paragraph 8.1, again, right at the forefront of Chapter 8 of the Code of Practice, states that the transition process must place children, young people and their families at the centre of that process. That's very rarely the case, unfortunately. Of course, we tend to see the worst of things. People tend to come to us when transition has gone really very horribly wrong and hasn't happened as it should have done. But very often children, young people and their families feel that transition is something that's happening to them rather than something that is happening around them and relating to them. Ultimately, you should be at the centre of the process rather than feeling like it's a load of nameless, faceless panels who are ultimately making the decisions that impact your life. And you're an afterthought, you know, your young person is an afterthought. And those aspirations should be set high. So I think for far too long, there's been a trend or a habit of deciding that children who have additional needs and disabilities can't set those high aspirations and aren't entitled to the same freedom of dreams and wishes as the rest of us. And of course, that's absolutely manifestly wrong. You should not feel that you have to set or encourage your child to set their aspirations low through any feelings that, oh, you know, there's nothing available in the system, so what's the point? You know, you really should be pushing to set those aspirations as high as possible and encouraging your child to do the same. I just wanted to make the point here that children and young people do have a right to change their minds. So if we're bearing in mind here, particularly for children with EHC plans, that the right time for transition is probably, well, should start at year 9 at age 14. I certainly didn't know what I was going to do with my life at 14. I think at that time I probably wanted to be a vet, which is very much not the path I decided to go down in the end. And I have had a few cases, more than I'd like to say actually, where we have been dealing with child's views, wishes and feelings, particularly in the post-18 context. So potentially they've done one course and actually they've changed their mind. They want to go into a different course and pursue a different field with a view to going on into a different employment. And the local authority have tried to argue, oh, well, those aspirations, you know, they had aspirations before, they have got what they need now to work towards those aspirations, and that is it. That's not the case. It's not anywhere near as clear cut as that. Obviously, there will be very specific facts of each case, but you don't have to think that your children are going to be pigeonholed into whatever aspiration they express at 14, as they are, for example, when they do reach adulthood and reach 18 years of age. So the SEN Code of Practice 2014 talks about planning, and it actually gives examples. So with regards to the planning, and I guess focusing on the fact that 14-year-olds probably don't have it all figured out yet, and in fact I'm fairly certain I still don't have it all figured out now, but it gives an idea of how we can approach preparing for adulthood in quite broad terms, with a view to narrowing it down as they place the end of secondary education and as they come up to phase transfer to post-16 education, which Hayley talked about phase transfer in her presentation that took place last Tuesday. But paragraph 8.21 gives some examples of how that could be structured. So it's just an example, it's not exhaustive, but I do think it's quite a handy thing to bear in mind when you are having discussions with your child's school or college about how they should actually be supporting that transition to adulthood. So the example given is year 9, age 14, that's your year 9 annual review, when the transition to adulthood and the planning process should begin. Explore aspirations and what different post-16 options can help them reach those aspirations. So it's not necessarily nailed down at this point. They might have a few special interests and subjects they're particularly good at that they might want to pursue. And you can talk in very general terms about those subjects, and generally about courses that might be available to them that would help them get to where they want to go in life. And that's introducing the subject in a nice, manageable way. I think it's not putting, you know, it's not overwhelming a child, it's not making them think they have to be making decisions straight away, but it's introducing the subject. Then year 10, looking at more specific courses and places of study in line with the child's aspirations is what I've put there, because so often it starts to drift, and particularly in year 11, once we are at the point of post-16 transfer, secondary to post-16 transfer, there's a nasty habit of the child's aspirations getting lost when local authorities are making decisions about placement. So I think it's really good to start nailing down those more specific aspirations, if it's possible to do so by year 10, so that you can say by the year 11 review that this is well thought out, this is a planned aspiration, this is what that child wants to pursue. So looking at potential courses that might be available, you know, you want to go into computer programming. Okay, well, what specific computer programming courses might be helpful for you, and which colleges or settings are able to offer a course that can actually enable you to move towards that aspiration. Obviously, not all courses are made equal, and I've had quite a few cases actually dealing with that secondary to post-16 stage. where the local authority will offer a hideously inappropriate college, was that the young person and the parent has expressed a preference for another. And as we say to local authority, okay, so you want to name Y college, this child wants X college. What course of study are you proposing for this child at Y college? And I kid you not, in at least 90% of those cases, the local authority hasn't even thought about course. Whether there's an appropriate course that matches that aspiration has not even passed the periphery of their mind. It tends to come down to how much does it cost and how far away is it? Are we going to have to provide transport, and how expensive is that going to be? And then by year 11, hopefully all being well, you've got your firm choices and specific placements, which you can ask the local authority to consult as part of your transition review in that year. It's important that you deal with it in your transition review if at all possible, because what that will do is allow time for effective transition. So what is effective transition will vary from child to child, of course. Some children may be perfectly happy just going along to the general open day along with their parents. But some children actually, to be able to sensibly attend college or to move on to the next placement, will need quite a gradual approach at transition. They may need to go to the site several times, even once or twice a week over a course of a term. It depends on their individual needs. So approaching it early paves the way to effective transition. If we don't approach it early, and so often it isn't approached early by colleges, by local authorities, transition tends to be rushed, and that's when you get problems. It does the young person a disservice. They're not getting the support that they need to transition. It's improperly planned out. It's knee-jerk reaction. This is places are receiving complaints, potentially they're receiving correction protocol letters and threatening judicial review, and everything's done in a rush, essentially to make it go away. And whilst that may move things forward, it's not necessarily moving forward in a nice, carefully planned manner, which you would like. In respect of social care transition, so I'm going to focus here very specifically on the social care side of things. There is no age that I can point you to. So there's nothing that I can say specifically in respect of social care. This is the age that transition should start, notwithstanding that there will need to be a start to transition for children with EHC plans in year 9. So that is a requirement that has to happen. But the real test for when transition in social care from children's social care services to adult social care services should happen is that it's at the right time. And that's, again, a very broad term, because what's right for one person, what's right for one child, won't be right for the next. And it could be at an earlier point than you would expect. So it could well be that it is sensible to do transition assessments for a 14 or 15-year-old child, depending on their individual circumstances and the various considerations that need to be given. What is important when deciding what the right time is determining that when there is going to be a significant benefit to the child. That's one part of the legal test with regards to social care transition, and I'm going to talk about that in a little bit more detail a few slides on. So the child to adult transition for social care, I am yet to see one go through smoothly. I do see the worst of it, but a little known fact about me. Before I came to SEN Legal, whilst I was doing my university-based training, I did actually support young people who were transitioning to adult social care services in a domiciliary care setting. And so I had quite a lot of experience actually of seeing how it can go badly wrong. Quite literally, sometimes young people arriving with us overnight with no clothing and no shoes, in fact, because everything had been handled so appallingly. It is often described as a black hole or a cliff edge, where you are moving on quite smoothly. Perhaps you've got your children's social care provision in place and you hit 18 and that all falls away. Services disappear overnight and actually nothing has been put into place in the interim. There is often very little or no transition between child and adult social care, despite the fact that the legislation specifically provides for it now as part of bringing the Care Act into force. And as part of the consultations, there was a really, really heavy focus actually on making sure that there is joined up and cogent transition between departments, but it's still, all these many years on, a real problem. And there are very often problems with the departments themselves not communicating with one another. So children's and adult social care services are generally a separate department. And when they were created and when they became separate departments, one of the concerns was that actually it would make communication worse. And I can safely say that this is still the case even when they are quite literally in the same room. So you can have these separate departments on opposite desks, and they are not talking to one another. They are looking at their own policies, they're looking at their own criteria, and never the two shall meet. It's really quite bizarre. And it can be an extremely frustrating position to be in. And it can be even more complicated when there is involvement from other agencies such as health. And I haven't got the time to talk about that this evening, but obviously there are also child-to-adult transition procedures in place for children and young people who are in receipt of healthcare services as well. And this remains the case despite the fact that it is in fact a local authority duty to coordinate, particularly to safeguard well-being. And I've put there the case law reference should you ever need it. You might take a snap of that so you can reference it in discussions with the local authority. So after all these consultations, after all these awful tales of woe and complaints to the Ombudsman, the Care Act 2014 came into being. And it now contains provisions which are specifically designed to smooth the transition process. And then coupled with that, there is also the Children and Families Act of 2014, there's the regulations and extending what was statements of special educational needs, now EHC plans, up to the age of 25. So all of this was intended to smooth the process. Unfortunately, that's really not what we see. So we still have a tendency to see local authorities treating 18 as some sort of firm cutoff, even where there is an EHC plan in existence, saying, well, this child is now an adult and the EHC plan has ceased, even though it can, of course, extend at 25. So it's not been quite the sea change, I think, that was hoped or intended. But what it does give us, if we do have problems, is something that we can point at to say this is where you're going wrong. But there is still ongoing issues. I'm sure there'll be lots of parents listening tonight who potentially have gone through transition or are coming up, who are saying we just don't know what's going on. The transition process is virtually non-existent. Looking at child-to-adult transition, and I hate to put on parents, I really do. You know, we are in a very fortunate position when we're acting for parents that we get to say we're going to take the reins here, and we are going to support you through this, and we're going to take over, because frankly I think you have enough on your plate. You've certainly got enough going on negotiating with education, health, schools, colleges, and often your child and meeting your child's needs to a significant extent as well. But what I would say when it comes to the child-to-adult transition is don't be afraid to be forward. So you are very, very well advised to be forthright on the subject of child-to-adult transition. If your child is in year 9 or beyond and this hasn't started yet, do push for it. If you have an EHC plan, make sure that people who are involved in the reviews are focusing on that preparing for adulthood, and keep pushing. And the reason I say this is because experience tells me if you don't keep pushing, it tends to die away. So you get them on board, you push them to get the process started. Let's start thinking about the future. You point to all the relevant sections that say they have to do this, and there's this mad flurry of panic because everyone thinks they've been caught out and they're going to be in a bit of trouble, and then it dies away. I'm afraid this is definitely something which you will probably have to keep shoving all the way to fruition, so all the way to the age of 18, and unfortunately potentially even beyond the age of 18. Keep records. I can't stress that enough. Local authorities have a really nasty habit, particularly social workers actually, of not emailing, and I see it more from social workers than anyone else. Education tend to rely on email, and so to a certain extent so do health. But I have in fact had social workers, even where the parents have needed reasonable adjustments to be made. So for example, if that parent has processing difficulties, and can't digest information fast enough during a telephone call, even then absolutely refusing point blank to put decisions and undertakings into writing. So do note them down. If you have a telephone call, make a note of who it was with, when it was, the time, and what was agreed. And a really handy way to do that, actually, from an evidential basis and a practical basis, even if they do refuse to email you, is to email them. So you have the phone call, they call you up, they have various things to say, and potentially they make promises to you like, I'll come back to you with an answer within a fortnight or something like that. Send an email to them straight away from your phone. It doesn't matter, you know, you can be on a train, you know, picking up the kids from school, just as soon as possible. Fire an email out to that person confirming that you spoke today on the telephone at whatever time. Here's a very brief overview of what we discussed, bullet points are fine. And then very clearly stating any agreements that they reach with you. So if they agreed, this is going to panel on the 9th of November, and I will get the decision out to you by the 16th of November, for example, you want to note that down, put that in writing and send that to them. That then puts the onus on them to dispute that at that point. So if you do find that it does all go horribly wrong and you are considering taking some action, be that a complaint or actually maybe even potentially judicial review, you have evidence that shows all of the failings from start to finish, essentially. And the local authority can't sensibly then say, well, we didn't reach that agreement, because if they hadn't reached that agreement, the expectation would be they would have emailed you back at the time to say, well, actually, no, that's not what we discussed. So down to the brass tacks of it then, the Care Act of 2014. I haven't stated it in full because frankly it's very long and I think more confusing than it really needs to be, and certainly for the purposes of this presentation. So I've just kept it to the key points because I don't want to bore you all to death. If you want to read it in full, absolutely, you can go and find it on legislation.gov.uk. It's all there in full. But essentially, looking at the assessment itself, the transition assessment, what section 58 says is that the local authority must, bear the word must, assess if it is likely that a disabled child will have care and support needs after transition, and it will be of significant benefit to be assessed. So the key words there are likely and significant benefit. That is, if you like, the two-step test when it comes to transition assessments between child and adult social care. And I'm going to talk a little bit more specifically about those two terms in a slide or so. What I just want to put in here, there is actually the possibility that the local authority will decide not to assess. And that could be because they're actually deciding not to assess at the moment. So not that they're saying no completely, but just not now. Or it could be that they are saying they're not going to assess at all. If they do decide they're not going to assess, they must give you written reasons for their decision. And I mean, that sounds very obvious, but very often actually those written reasons aren't forthcoming. So it could be that you've made a request for transition assessment, that you feel it's the right time for that assessment to happen, and that request just falls into the void. It goes over the cliff even before you get to the age of 18. Or that you'll receive a letter arising generally from a panel, which is quite literally one side of A4, including addresses, and just says we're not assessing at this time, full stop. They do have to give you written reasons for their decision. And if you don't get those written reasons, you really need to press for them, because if there is action going to be needed to be taken, potentially at this point by way of a judicial review, really you need to know the basis for the decision to decide whether or not you have a viable challenge. And secondly, if they're not going to assess, they have to give you information and advice about what can be done to prevent or delay the development by the child of needs for care and support in the future. So if, for example, the local authority say, we're not going to assess because actually we've decided that it's not likely that your child will have care and support needs after transition. In fact, we don't think they'll have any entitlement to services at all go away, they can't do that. What they have to do is actually say, well, here are the things available to you that aren't provided through local authority social care services, the strategies, the various outreach programs, things under the local offer, which are available to you without a care plan in place, in order to prevent those needs or delay those needs from worsening and developing to the extent that there would be entitlement to social care provision under a care plan. But it is good news to most that the threshold for an assessment is low. So that test, that likely, the test that I set out earlier, it is a low test. So it should be very, very few and far between that an assessment is refused outright. More likely that an assessment would be refused on the basis that the local authority have decided it's not the right time. So, for example, they think it's too early. This child is only just coming up to the end of year 11, and so we can't be looking at adulthood yet. They've got college to go before, or something like that. And the fact that a disabled child may not require social care support services as an adult is not a reason to refuse a transitional assessment in and of itself. So just because they've said, okay, we've looked at the child's needs, potentially under the care support that they're receiving as a child, and actually we don't think that they will qualify for, they won't be eligible for services as an adult, that in and of itself is not reason to decline an assessment. And that's because the care and support statutory guidance actually makes it very clear that even for those children and young people who may not be entitled post-transition to provision, that it can be a really useful tool and a useful way of sort of ascertaining and providing that signposting to prevent those needs from developing and hopefully in the future requiring care support through a formal social care package. So the assessment itself is not a guarantee of provision, but it can still be of benefit. It can still be of benefit to a child to be assessed, even if there's not going to be provision at the end of it. So focusing now on those terms. So the first of them obviously was likely need. And the flesh on the bones of this can be found in the care and support statutory guidance at paragraph 16.9. And what that sets out is that a young person or carer is likely to have needs if they have any likely appearance of any need for care and support as an adult. So that, as you appreciate, is very, very broad. It's not requiring definitive proof that there is going to be eligibility or definitive proof of need in adulthood. It's only likely that they will have, or that they have any likely appearance of it. So it's a really, really easy threshold to pass and should go some way to triggering that transition assessment. And I've copied there and pasted the specific part of the guidance that you'd want to refer to. Again, you can access the full text online. What can be useful with regards to proving that likely to have needs and likely appearance of needs is actually if your child is already in receipt of provision through children's services, you can argue, well, it stands to reason they have eligible needs now that have been assessed, and these are those assessed needs, and they are likely to have them as an adult and therefore require a transition assessment. And it's also very worthwhile pointing out now under this heading of likely need that when a local authority is making decisions as to whether or not a child or young person will have likely needs and ultimately whether they will require provision, is that they also have to consider whether a parent is actually willing to continue providing the provision. So reaching the magic age of 18, your child will become an adult. They are legally an adult. They are defined as an adult by law. And what that means for you as a parent, although it seems very distasteful to say, is that actually the obligations, for example, to provide accommodation, which you had when your child was a child, no longer exist. So if you have been up to the age of 18, essentially saying to local authority, well, we'll provide, okay, our child has eligible needs, but we are meeting all of those needs ourselves. We are doing the day-to-day. The local authority cannot assume that that will continue into adulthood. And if you want to increase the likelihood of your child being able to access adult services, then it is well worthwhile you considering actually, are we willing to continue to do this in the future? Because of course, if you're not willing to provide that support in the future, then that is where the local authority should step in. You're not obligated to. Obligated is a very tricky word when we're talking about our kids, I know, and I don't mean to sound dispassionate and heartless and a typical solicitor, but ultimately that's what it is. It's an obligation. And you are not obligated to provide that care in lieu of the local authority stepping in and doing what they have to do. So that's the first part of the statutory test, if you like, for transition assessment. And the second part is significant benefit. So significant benefit doesn't actually relate to the provision. So it's not, oh, it will be of significant benefit for this child to be assessed so that they can get their hands on provision in adulthood. Significant benefit actually relates to the timing of the transition assessment. So it makes, it makes no statements as to eligibility for provision, and it doesn't focus at all on what this child or young person may be entitled to once they reach adulthood. It is looking at the timing. Is it of significant benefit to that child for the transition assessment to happen now? Essentially, it's a time issue. And that also feeds into the fact, of course, that a transition assessment may need to go ahead, even if it's not likely that that child will receive services in adulthood. So there's no requirement to establish that there is a likely or indeed any obligation on the local authority to provide provision through adult services. So looking at timing, paragraph 16.6 of the statutory guidance sets out really quite sensibly that the timing of this assessment will depend on when it is of significant benefit to the young person or carer. So that's relevant as well, thinking of yourself as a carer. Of course, if you are coming up to the limits of what you're willing and able to provide as parents, if you are thinking, actually, we're not willing to provide this level of care and support anymore, that may mean that it is of significant benefit to your child to be assessed then, because ultimately at the age of 18, you are going to step back from that primary caring role that you may have taken on. It should be ideally at a point when the needs for care and support as an adult can be predicted reasonably confidently. So it should hopefully be at a time with adult transition not too far in the future, so the age of 18 not too far away, and things relatively stable, so that actually you can say with a reasonable amount of certainty what provision is going to be required post 18. If things are a bit tumultuous at the moment, for example, if your child has quite literally just changed placement, or if there is something going on in the family relationships, a whole host of different reasons can be given. But the local authority may actually say it's not the right time, it's not a significant benefit, because we can't predict reasonably confidently what the needs as they present now will be consistent with the needs they will present when they reach adulthood. So ultimately, it will vary from child to child and from situation to situation. So there's no set age. Every child and young person, every family is different, and it really should be person-centred. It should be when it's most appropriate for the child and for the family. So local authorities may have policies that basically say we won't do an assessment before this age, or the assessment will start on the 17th birthday, or something along those lines. That's not how it should work. It shouldn't be set down in some fixed local authority policy. A local authority is entitled to have policies that may indicate the norms of what they may or may not decide to do. So they may say normally we wouldn't look at this before 17, for example, but they can't then use that policy to fetter their own discretion. They do have to look at doing these assessments, these transition assessments, when it is of significant benefit to that individual child. So looking at when is the right time, and paragraph 16.10 of the statutory guidance set out some of the considerations that can be taken into account in deciding when the right time is. Now, these can be used for you as well as against you. So if the local authority is trying, for example, to rely on some stock local authority policy that says they're not going to look at this before the age of 17, for example, then you can use the considerations in paragraph 16.10 to, if you like, put forward your argument that actually now is the right time. So, look at your young person. Where are they at school? Where are they at with their exams? Do they have a clear trajectory on what they want to do in adulthood in terms of work? If so, then now may well be the right time for them. Do they want to go into further or higher education or training? Do they want to get a job? Do they know what they want to get a job? Do we need to be focusing on what provision is going to be required in order for that person to access the world of work, and preferably in a job of their choosing or something that they would want to do? Are they looking to move out? Have they said, now is the time, Mum, I may not be going to university, but actually I still want to have that leaving home experience? So you can look at all those factors And if you can satisfy yourself under those factors that actually you could ascertain with reasonable certainty what those post-18 needs are going to be, then that will strengthen your request for a transition assessment in the event that the local authority are refusing. So if you contact your local authority to request transition assessment and they decide now is not the right time, and even if you've gone through all of those bullet points and things that I suggested there and they've still said no, the onus is then on the local authority to contact the young person and the family to say when the assessment will happen. So it's not just a case of saying, no, we're not going to do it, we're not doing it, goodbye. What they should be doing is providing you with a clearer idea of when the assessment will actually happen. So you shouldn't be left guessing, and you shouldn't be left making repeat requests for assessment, because inevitably, if the local authority don't give you a clear idea of when that transition assessment will take place, you will end up putting in request after request, if for no other reason than to kick people and to keep them focusing on that transition to adulthood, so that you don't find that nothing is in place by the age of 18. And that is set out in paragraph 16.15 of the statutory guidance. And it's also worth mentioning here, because of our children, young people are three-dimensional, and they exist across all hours of the day, not just the education and not just outside of school. You tend to have lots of agencies involved in the children's lives. That could be education and social care, it could be education and health, it could be all three. And so it may be that one body takes the lead more than the other. So for children with EHC plans, it's almost inevitably going to be education. And as part of the EHC plan reviews that lead the transition itself, if there are children with extensive health needs, then they may find that it's actually CCG that is driving that transition process. Or, as is very often the case, it may be their own family who are really pushing it because nobody's doing anything. But the key point is that whoever is taking the lead, whether it's education, whether the education officer in the annual reviews, or the college and school in the annual reviews, whether it's health, whoever is taking the lead, the onus and the assessment itself is on social care to undertake that assessment via the Care Act 2014 provisions. So it is their responsibility, and social care, for example, can't say to you, oh, well, this has been dealt with under the EHC plan, so that's education's problem. No, it is social care that have to make those decisions and undertake that assessment. So post-18, you've gone through transition, hopefully. There has been some form of transition, but sometimes not, very often not. So post-18 and what happens now? So assuming that there has been a transition assessment and that some form of transition has taken place, when the child reaches the age of 18, the LA then have to decide what to do with that assessment. So they can treat the transitional assessment as a needs assessment under the Care Act, or they can decide whether a further needs assessment under the Care Act is required. So although the transition assessment is focused on making sure that there is something in place post-18, it may be actually that by the time you get there, the local authority say, well, we're not using this assessment actually as a needs assessment and we need to do a further one. In reaching that decision, the LA should be considering when the assessment was carried out, and also looking at the circumstances. So have there been any significant changes during that time that mean there may need to be a further assessment? So, for example, a significant change could be a change of placement. This young person, since the transition assessment happened, may have gone to a residential college, or heaven forbid, there may have been a loss in the family. A primary carer, a primary caregiver may have passed away since the transitional assessment was undertaken. So if there have been significant changes like that, then it's very likely that a further Care Act assessment is needed to take account of those changes in circumstance. If the local authority have decided that the person, not the child anymore, the person, if their needs will be met under the Care Act 2014 after they've turned 18, they must undertake the care planning process as for other adults. So as if they've done a care needs assessment for somebody who's 20, 30, 40, and that includes creating a care and support plan, which should be agreed as far as possible with the subject of the plan. So in this case, your child who's very recently turned adult. or yourselves if your child lacks capacity and you are advocating on their behalf, and producing the personal budget, so setting out what they would expect those care services under the care plan to actually cost. Funding should be addressed at a very early stage. So all too often, funding is very much the last thing on anybody's mind, including the local authorities. Despite the fact that they are so money driven, it almost tends to be an afterthought, and certainly wanting to be done as cheaply as possible. Actually, under the guidance, it says that funding should be looked at very early on and should, as far as possible, be agreed in the early process, where it has been identified that that young person will require funding after they turn 18. And that all leads into that seamless transition. So if we've talked about funding, we know what our needs are, we know what the provision is, and we know what the budget is. There is the necessary information there to be able to do that handover and make sure that there are services in place. So there should be no cliff edge or black hole provision. And this is enshrined actually through all of the documentation, whether it relates to the Care Act or not. So the Code of Practice, as well as the statutory guidance, all makes really clear, and in fact, the guidance relating to health says there should be no cliff edge or black hole of provision. I only wish that that were true. I only wish that I could tell you that this has eradicated those problems. Unfortunately, that's not the case. There does still tend to be that drop off where transition hasn't happened properly. But at least the principle is that under no circumstances should a young person find themselves suddenly with no care and support as they transition to adult services. So very few moves from children to adult services will or should take place on the day of someone's birthday. What they mean there is that the actual transition, the assessment side of things, the decision making should have happened before the age of 18 has been reached. Under section 66 of the Care Act, there's a very interesting little provision. And what this section takes into account is that actually for a lot of children and young people who have special educational needs, there will be competing and often interlinking legislative provisions. So, for example, if we're thinking of the many 18-year-olds out there now who have an EHC plan potentially up to the age of 25, so they will have more than one statutory support, if you like. They'll have their EHC plan, they'll have their reviews, they'll have their care plan. Although where there is an EHC plan in force, the social care sections of the plan should essentially take precedence, or rather than having a separate care needs assessment, although there will be one, it should still be a central document that everybody can use. But what section 66 allows, and I say allows because it's not a requirement, it's a power rather than a duty, is it allows the authority to continue providing support under the Children Act or under the Chronically Sick and Disabled Persons Act. So those are where the assessments of children for social care come from, post 18, even though they've reached that age of 18. So that again provides another fallback of, okay, well, if the transition isn't in place and things haven't happened as they should, then the local authority can continue to provide the services through children's services, either under the Children Act or the CSPDA as appropriate, to ensure that that cliff edge doesn't happen and that provision doesn't just fall away. If the local authority decide not to treat the transition assessment as a needs assessment, so this is going back to the local authority, they've got their assessment, your child is 18, and what do we do with this assessment now? Does it become a needs assessment, or is a further assessment necessary? If they decide not to treat the transition assessment as a needs assessment, then they do have to undertake a new needs assessment under the Care Act. Okay, and in the meanwhile, they have to continue with the previous provision and making that provision to the child or young person until it is made an eligibility determination. And this is by far, in my experience, what local authorities fall foul of more than anything. It's where they're late to the party, the transition hasn't happened often, and they are now saying, okay, well, your child is 18 and we're now going to go through the needs assessment process. Your services have ceased through children's services, so you're no longer receiving any budgets or provision through children's social care. And we're not going to give you anything until we've completed our assessment and decided what it is that you should be entitled to. They can't do that. And it tends to be a relatively quick and easy challenge, because what local authorities don't want is long protracted proceedings in the High Court about this. In fact, very few cases go that far, because the local authority essentially just settle and want you to go away. But they can't just withdraw that provision until they've made an eligibility determination, and until that care plan is in place following the needs assessment. Then it should continue with that provision seamlessly. So your child should continue to receive that provision. So there shouldn't be gaps in the provision of care and support on the 18th birthday. If steps haven't been taken to decide necessary care and support before then the existing services must continue until those steps are taken. And just at the end here, I'm setting out very briefly, again because of time constraints, that the steps the local authority then must take are either concluding that the person does not have the needs for adult care and support, and whether or not that decision is a lawful one. It goes beyond the remit of our discussion today, but that's one of the decisions they could make. They could say, okay, we've done our needs assessment and actually there's no eligibility here. There are no eligible needs for adult care and support. Concludes that actually this person does have some needs and starts to meet some or all of them under adult social care services. So that's when that provision from children's services can start to fade away. Or concludes that actually this person does have needs, but they're not going to meet any of those needs because they don't meet the eligibility criteria, which again, unfortunately, we don't have time to discuss, but I'm sure will be the feature of a webinar in the very near future. So really quickly now, mindful of the time, rights of redress. So there are 3 potential rights of redress open to children, young people and their families who have failings with regards to the child to adult transition process. The first potential right of redress for children who have, or young people who have EHC plans, is through the extended appeal. So an extended appeal is an appeal to the SEN tribunal, which has a primary education focus, if you like. You have to have an education right of appeal and something you want to say about the education sections to bring an appeal. But as part of that appeal, you can ask the tribunal to consider the contents of the social care sections of the EHC plan. So that's one potential right of redress. If that isn't open to you, then you have the option of a complaint. So you can complain through the local authority's own internal procedures. And then when you inevitably don't get the answer that you want, onto the local government ombudsman. And your final option is judicial review. So that is challenging the local authority as a public body for their failure to undertake the transition procedure appropriately and correctly in accordance with the legislation and the statutory guidance. By far, what I would say, a lot of social care matters have a huge amount of urgency attached to them. And I really mean a huge amount of urgency, especially if your provision has disappeared. Extended appeals and complaints in those circumstances are not going to be much use to you, unfortunately. They are far too slow. Judicial review may be the only sensible option open to you. But as I said, my colleague Richard Nettleton is going to be talking about those in much more specific terms in a couple of weeks' time. So I'm going to take a breath. That was a lot of information in a very short period of time. And I'm going to be joined now, I believe, by Hayley, who is going to put to me some of the questions that you've been asking while I've been talking.
Thank you very much for that, Nicole. That was really helpful. We have had quite a few questions. We've busily been trying to answer as many of them as possible in the Q&A section, and I've flagged some that I think would be helpful to answer live, just because they seem to be a bit of a reoccurring theme throughout tonight's presentation. So to start with, an all-encompassing question from Kate to start with. This has got a couple of different elements which kind of cross both of our speciality areas, but it says, can a young person 18 be forced to go into supported living accommodation against their wishes? Social care are looking to carry out a capacity assessment with a view to take it and dolls to the Court of Protection. Kate adds, I should add that she is academic but has high anxiety levels, which leaves her room bound. The capacity issue relates to weighing up of the issues. So we can only answer obviously on the basis of kind of broadly, obviously, because we haven't got the specific information about this person. Obviously, we've both dealt with these where young persons are tried to be forced by local authorities to go into supported living, generally because it's much less expensive. So I don't know if you just want to address that to start with across those different areas.
Yeah, no problem. So, I mean, the short answer there for you, Kate, is no. And I have to say this is very much going on the limited information that we have available. So another part of the local authority's duties when they're making decisions for young people and they're taking into account their views, wishes and feelings is actually their human rights as well. They have to bear those in mind. And there is, in fact, what I suspect will be quite useful to you, a specific piece of case law which actually dealt not exactly the same circumstances, but concerned a young person who'd been attending a residential college and wanted to return to live at home. And the local authority didn't deal with it and actually was found to have breached their right to a private and family life. So when they are looking at making decisions, it should be very person-centred. They should be taking your child's views and wishes into account. And I'm assuming from the wording of your question that actually your child doesn't want to go and live in supported living. So what the local authority should actually be focusing on is whether or not, sorry, I've just had a total mind blank. So what the local authority should be focusing on is what provision is required in order to make it possible for your child's aspirations and their views to come to fruition, for her to be able to stay at home. The dolls and the capacity issue takes it a step further. It's something we come across quite frequently, actually. It's becoming a bit of a hot topic, these complicated applications to the Court of Protection, where we would argue local authorities are using capacity, if you like, as a smokescreen to get their way. So they're essentially trying to argue, well, this young person has no decision-making capability. We don't agree with the decision that the parent has made, and therefore we're going to try and use the Court of Protection as a mechanism to be able to remove that young person from their home and place them in supported living, seemingly against their wishes. And, you know, whether or not they would have any luck there really comes down to the facts of the case. I don't know if Hayley, you want to add anything more onto that from the Court of Protection perspective.
I would just say, yeah, Court of Protection is to be used in very specific circumstances. So firstly, it obviously is only for somebody who's already lacking capacity and can't make decisions for themselves. And obviously that is a really key issue, particularly for this person, because they're saying they're very academic, but they suffer with anxiety. So it might just be that they're being portrayed. It might be that the capacity assessment that's being done, the local authority is saying they don't have capacity, is just because it hasn't been tailored for that particular young person. And obviously we talked about last week, sometimes capacity assessments have to be done several times at different times of the day. You know, is the young person being assessed somewhere where they're comfortable? Are they in their home environment? Are they supported? If they've got language difficulties, for example, difficulties of communicating, is a speech and language therapist involved? These are all the things that the Court of Protection will look at. The Court of Protection is very resistant to make decisions, particularly about where people live, particularly if another court has got mechanism for deciding that as well, if they've got jurisdiction. So sometimes we see local authorities trying to take things into the Court of Protection arena, but actually if the young person has an EHC plan, which isn't clear here, and you can actually deal with this as part of education tribunal, for example, if you were seeking not supported living but an education setting, then that the rightful place to decide that is in the education tribunal, the SEN tribunal, and not in the Court of Protection. If you do find young people are being kept somewhere against their wishes under a DOLS, that's again a separate issue, and that's why I picked it first, because there's DOLS here, capacity and social care. If somebody is being kept somewhere untoward against their wishes, then certainly you can make a Section 21A application against challenging that DOLS if you don't believe it's being put in place properly. But you can see, Kate, it's quite a wide-ranging question, and we're limited to what we can say with the information that we've got available, although Nicole and I would love to talk to you about it for ages because it comes across both of our fields. I just wanted to ask one of the more next questions, Nicole. We've got, where does the ultimate responsibility lie for ensuring that transition is considered in EHC plan reviews from year 9, the school or the local authority? Okay,
well, the answer is there's a bit of both. So the statutory responsibility for ensuring that reviews actually go ahead is a local authority obligation. So it is ultimately the local authority's job to make sure that annual reviews go ahead on an annual basis, and then obviously in transition years in time for the transition decisions to happen. What the legislation does provide for is for local authorities to hand over the responsibility for calling a review to the schools, which they almost always do. In fact, I'm yet to see a local authority that says, yeah, we'd love to add arranging reviews to our workload. When you look at the code of practice, the onus is very actually heavily on the school and college. And that's a reflection of the fact that they are the people who are with your child all day, every day, or every school day anyway. And therefore, they are far better placed to be having these discussions. They know your child. Hopefully, they have something of a rapport. They can integrate it into, for example, their employability lessons, or when they're looking at careers development and careers advisory services. It's far better for them to do those sort of face-to-face discussions rather than some nameless faceless person at the local authority who, let's face it, probably won't be in post by the time the next review comes around anyway. Your focus, I think, from a practical perspective, should very much be with your school or college, depending on where your child is at the moment.
I just wanted to also give a little bit of hope. I know that obviously these webinars are challenging parents. Lots of parents are facing difficult problems. One of the things that Louise has said here is, I keep hearing about how adult social care is rubbish and everything is geared towards children's services. All of these children grow up. When our children turn 18, they have to have a good quality of life and be able to contribute to society, even if they're not able to work or do further education the traditional way. Are there any good news stories here? And I would say, Louise, we have the benefit and the negative of, we see the best and the worst of cases, because obviously people generally who are coming to us have tried everything. They've been fighting with their local authority and they come to us for help. But we also have the benefit of working with the families who we've been working for a number of years, who we've followed through education, and we actually do see the good news stories with social care for those families as well. So just by way of an example, we've got plenty of clients who might have been in an education placement coming up to the age of 18 or 19, and they've been under an EHC plan and being kept in, for example, a waking day residential placement. And then at the age of 18, what parents in that situation do is they start looking for somewhere for their young person to transition to in a social care setting. So it might be that they're going into a purely social care setting, like someone like, there's many providers, but someone like Home from Home Care are a big provider of social care services, who have kind of a supported living environment where you get support workers on site, but they can also live in their own flats and go out and do activities, etc. Or some residential education settings you can also stay on at for social care. And we see many families who actually go through an EHC plan and then at that stage move into social care, and social care do actually take over the funding. So some of these young people have actually been in the same setting, and provided that goes on into adulthood, they then kind of just continue in that placement with their peers. So just for, and I'm sure Nicole will share some more as well, but we do actually see some good news stories, and they're the kind of celebratory success we celebrate in the office. But there are good things happening. Certainly they are very carefully managed, and they've normally, had attendance at the annual reviews and making sure all of these steps that Nicole has addressed in her presentation has been followed. It's not something that just we conjure up overnight, but with a really careful transition and following of social care services, some local authorities are actually getting it right. We see plenty that aren't, but some of them certainly do. I don't know if you want to add something on to that, Nicole, because obviously we do see some of the good stories as well.
Yeah, we really do. I mean, it generally takes a lot of kicking and a lot of forcing it through in order to make sure that people are doing what they say they will when they say they're going to. But absolutely, I see social workers who are very understanding. They're willing to arrange for very lengthy transitions, for example, from residential education provisions, maybe where this child has been for a long time, and moving out is going to be a big deal for them. Understanding that the next move should be the permanent move, it should be the final move. And we do see good things, and we had some really quite positive news looking at local authority bad behaviour, if you like, and touching on Kate's question about the interaction with the court protection, how that's being used. We very recently had the absolute pleasure of saddling a very naughty local authority with a very heavy hefty costs bill for trying to use the court of protection to get their own way, when actually that isn't where they should have gone. And although it certainly took time to play out, the court, once it got to final hearing, really didn't take too kindly, and it was really quite not nice and easy to wrap up, if you like. So yeah, it isn't all bad, but what I would say is that it tends to be better where people are actively managing the process. So ideally, there should be a single point of contact for you. You know, the local authority should be providing somebody who's coordinating the transition. That very rarely happens. And parents who have the ability and the time to try and step into that gap tend to have a better deal of it post 18.
We've only got time for a couple more questions. I let the questions go on a little bit longer, Nicole, because you filled your whole hour of your presentation, but we've got a couple more that we can squeeze in. There's a couple of questions around this same theme, so I'm going to actually ask Alison's question, but it will answer some other people's questions as well. So Alison's question is, how do you know what sorts of things adult social care can offer your child? My son, 18, has had an adult social care transition assessment under the Care Act, and despite several diagnoses, including ASD, PDA, SPD, severe social anxiety, bulimia, and bipolar type 2, all of they offered was a PA, which my son was incapable of engaging with, so they closed him to adult social care. And obviously, you know, that's a disappointing position to be in, and lots of families will find themselves in that position. So really, lots of the themes of these questions are, how do we know what's on offer from adult social care, and what can we get access to?
Okay. There are a few different answers to this question, which I'm sure Alison will really, really appreciate, just to make things extra confusing for her. First thing I want to signpost you to is the local offer. So there should hopefully be some information available under the local offer as to what provision is actually available locally to give you, a starting point, if you like. In terms of the more general question, what actually can be provided under adult social care, that is really how long is a piece of string question, because it should be completely person-centric. So I completely understand your situation. The local authority have obviously assessed eligible needs. They said this is what the eligible needs are. And then they've offered a provision to meet those needs, which he cannot access. And that is irrational. You know, that is not, and then to say, okay, well, he has eligible needs, he can't use a PA because of his additional needs, because of those particular needs that he has. And therefore, we're going to do nothing is discriminatory. It's direct discrimination. It's difficult. It's obviously so hard when you can't talk to people. But ultimately, as part of the process, it would have been a good idea for you to be thinking out about actually, well, what can my son access? Because under the Care Act and under the provisions, particularly in relation to social care budgets, where you sort of take the money and you manage your own social care, as long as that money is being used to meet the eligible need, then you can almost utilise it however you like. So if that is finding day centres for him to go to, you know, something in the area to pursue an activity that he might enjoy. If it is, rather than having a PA be with him all the time and trying to take him out into the community when he doesn't want to go, is it actually having carers come into the home to provide support with personal care or the development of independent living skills. It really depends on your son and his individual needs. And what would be so beneficial to you if you're able to afford it is an independent social work assessment. So an independent social worker can, they do exist, and I assure you they really are independent. They will come along and they will make recommendations based on what your son needs, you know, what his needs are, what provision he can access, as opposed to whatever pro forma tick box the local authority is ticking. A PA would tend to be one of the cheaper ways of meeting need, and the local authority is entitled to suggest provision which is cheaper, which can equally meet the need if you're suggesting something else, but only if both options are viable options for your son. And ultimately, if you can't access the PA because of his diagnoses and because of his difficulties, then they have to come up with something else. So, I mean, that challenge to me sounds right for a judicial review. And as I said, local authorities, there is so little case law in this area of law, because local authorities do not want to go to the High Court over these matters. they tend to settle relatively quickly. So that's really something you should look into.
Just the final one that we're going to cover this evening, Nicole, then, and I will let you go and get your daughter to bed, as well as everybody else, letting them go to get their children in bed also. We touched on this last week. We covered it in my presentation, but I think it's probably worth reiterating because we obviously see it time and time again. So a question from Diane is, can the local authority change an educational placement of 3 years to social care? So this seems like a situation where obviously you've got a young person turning into an adult and suddenly the education placement has become a social care placement.
As if by magic. Short answer, Diane, is no. So it has to be fact and situation specific. But the fact that a child has been at a placement for 3 years does not magically mean it's no longer educational. Hitting the age of 18 or 19 does not mean it's no longer educational. This tends to happen a lot. A lot of local authorities get young people to the age of 18, 19, and then will quite literally say your child is now 19, and so they move over onto adult social care. That's not how it works. An EHC plan can continue up to the age of 25. That's why the law was written as it was. What you really need to be establishing actually is whether that EHC plan should be continuing, whether it should be continued to be maintained. Hayley touched on this in her webinar last week, but if you go and look at our back catalogue of webinars, we have actually done a specific cease to maintain webinar, which sets out all of the legal provisions with regards to making arguments for education versus social care, the correct legal tests to be applied, and how you can put that to the local authority. If they are saying it's now social care, I would imagine that you have a cease to maintain decision either in your hand or about to be delivered to you courtesy of the local authority. So I really think you should go and give that a watch if you have the time.
Thank you very much for that, Nicole. I'm sure that was gratefully received. We tried to get through as many questions as possible, but as usual, we were inundated. So we have tried to get through as many as possible. To all of those watching, what I would just say is we do read all of your comments that you send to us via email if they come through to us on our social media channels, all through the subscription to the webinar series. So if you did find this session helpful, please do reach out to us on social media and certainly tell other parents that you think it would be helpful for them to have a watch of, because obviously we are stronger together. So it's really helpful that you can share this webinar to anybody that you think might find it useful, and also feedback to us, because the only reason we put these on are to assist you going forward. So if they have been helpful and if you think there are further topics that you need to be covered, please do reach out to us and we'll endeavour to fulfil all of your needs in terms of, you know, blanks in the law and try and fill those gaps for you. But for this evening, I think we've taken enough of everybody's time. It is getting late, so I can just thank you, Nicole, for your time this evening, and thank you to you all for watching.
Bye everyone.